The Emergencies Act Commission wrapped up this week with appearances from high-ranking government officials. Janice Charette, the clerk of the Privy Council and the head of the Public Service, and Nathalie Drouin, the deputy clerk. They both testified on the number of meetings between cabinet, senior officials, and the Prime Minister that ultimately led to the government invoking the Emergencies Act for the first time in that legislation's history.
There was some importance to try and get this moving once it looked like that's the direction things were going to be moving in. We wanted to be able to move quickly. And the Prime Minister, he will tell you his own story about this. He was eager to make the decision and to move forward.
Okay, as Ms. Charette said, the Commission will hear from the Prime Minister next week. We're all looking forward to that testimony. But first, we're going to go to the CBC's Karina Roman has been following the testimony today. And Karina, these are some of the, these are the top-ranking officials in the Canadian government. What sort of insight did they give on how the Prime Minister came to the decision to invoke the Emergencies Act?
Well, I mean, they talked a lot about all the meetings and the steps that got them there, but let's get right to that first ministers' meeting on February 14th when that eventually the decision was made to invoke the act. What was interesting, of course, with the Prime Minister meeting with the premiers, we know that some premiers were supportive, some not so much, but what was very clear from the testimony today is that meeting was a consultation. They were not looking for consent. Now, after that meeting, basically the wheel started moving in the direction of invoking the act. Charette, the Privy Council, the clerk of the Privy Council, doing a memo for the Prime Minister recommending the Emergencies Act and with a basis for that recommendation. Now, this fundamental question that keeps coming up of whether the threshold was met in terms of the definition of a national security threat, lots of conversations about that it has to meet this Section 2 of the CBC Act definition, and others from the government this week saying, no, we're allowed to look more broadly than that at the cumulative effect of everything that was going on. Well, today we really got sort of our first lengthy insight into what was going on in the government's mind in terms of their rationale and how they got to that decision. So just to be technical, they relied heavily on Section 16 of the Emergencies Act, which allows for a broader definition. In layman's terms, basically it is the accumulation of everything that was going on. Have a listen to what Charette had to say.
The decision maker in the Emergency Act is not CBC. There's nothing in Section 16 which says the governor and council, who is the decision maker, who's being asked to make the decision, has to ask CBC if it's okay. The governor and council is asked to assess whether, on reasonable grounds, that there is an urgent, critical, national situation where the health, safety of Canadians, their lives, their livelihoods, the national security of the country is at threat of serious violence.
And so with that in mind, they did feel like the threshold was met and, of course, then invoked the act. She also talked about how in her decision, she was conscious of all the accountability measures with the Emergencies Act. So she was comforted by how robust those measures were, that these were just going to be supplemental measures. They weren't going to supplant what provinces could do. They were targeted. There was a time limit. And of course, there's the Joint Parliamentary Committee that looks at it afterwards, and this very inquiry that's happening as an accountability measure as well.
Okay, so Ms. Charette and Ms. Drouin, they're the last officials to appear this week after really a string of advisors to the Prime Minister testified. Was their testimony today any different or explanatory from what the Commission had already heard this week?
There was quite an expansion on what we'd already heard this week so far from government officials, very much in line with, the economic concerns that were going on, that kind of stuff, which we've heard a lot of this week. But there was quite some anticipation into what these officials would say about the Brenda Lucki testimony we heard earlier this week. That's the RCMP commissioner who said her thoughts on the fact that the policing tools had not been exhausted, that they had a good policing plan that did not require the Emergencies Act, that she was not called upon in a very key February 13th meeting of the incident response group. So she never relayed that information to the cabinet ministers and to the Prime Minister and others there. And of course, then we heard yesterday from the National Security Advisor saying if she had important information, there was nothing preventing her from bringing that up. Well, today, Charette said that Brenda Lucki, if she didn't feel comfortable bringing something up at a meeting, that her door was always open for a one-on-one. But also we heard from Nathalie Drouin saying, well, of course the RCM commissioner will say that the police force can still do stuff. That's her job, is to express confidence in the police force. But then she went on to say this. Have a listen.
Can you imagine if we have waited for the commissioner to say, I'm overwhelmed, it's over, I can't do that? So we wouldn't have been in a situation of threat. We would have been in a situation where the threat would have materialized.
Now, Charette also added to that concept, that idea that the information that Brenda Lucki said she had that might have swayed minds in some people's heads about whether or not they should have invoked the act actually probably wouldn't have swayed either way, that it wasn't the be-all and end-all. It wasn't the only factor they were deciding, that there was so much on the table, so much information they were looking at, that it might not have been as pivotal as some people think.
Okay, Karina, thank you so much. That's the CBC's Karina Roman live tonight in Ottawa. Well, earlier this week, the Commission heard from other top government officials, including the National Security Advisor and the Commissioner of the Royal Canadian Mounted Police. Time now to bring in our weekly panel of experts. Stephanie Carvin is an associate professor at Carleton University's Norman Paterson School of International Affairs. Professor Carvin specializes in national security issues. Leah West is an assistant professor at the Norman Paterson School of International Affairs, and Professor West specializes in national security law. Stephanie Carvin, I'd like to start with you if I can. The Prime Minister's National Security Advisor, Jody Thomas, she testified this week, and she really took issue with the CSIS assessment that the convoy and all the related protests wasn't a national security threat, in effect saying that the CSIS definition is too narrow. The government needs to look at a broader picture than what CSIS is tasked with doing, and that really maybe it all needs to be updated to reflect the modern reality. What's your take on her assessment?
So, yeah, I mean, I don't think it was so much taking an issue with the CSIS assessment, but rather perhaps other people's interpretation of it, right? So CSIS is not the one that invokes the Emergencies Act. They don't give the yay or nay. They do give advice to the government to say whether or not, in their view, there is a threat to the security of Canada. And for a number of reasons, Jody Thomas said that they have to take that narrow view because of the level of scrutiny they're under, because of all the judicial authorities that they require, and because, frankly, it's a pointy end of the stick agency. They have to kind of be careful with how they actually use their powers. So they take a much more limited view as to when they can use their powers to address threats to the security of Canada. Her argument is that we're the government. We can take a much wider view of what these threats are and when we can use our powers, because, we're doing different kinds of things and we can look at different kinds of information. So that was the argument put forward, not uncontroversially, but I think this is going to be the main point of contention from here forward.
Right. And so, Leah West, what's your view of Jody Thomas's argument there?
So I think her argument wasn't necessarily well articulated, and that's why she tried to refrain from making it and left it for the clerk and legal lawyers today. And I think they just did a better job of articulating what their position was, really, which was, as Stephanie just said, it's not just about the threat to the security of Canada that CSIS would base an investigation on, but it's the totality of the circumstances, looking at the words in 2C and placing them kind of in a broader context. And so I think that is a very interesting take. It wouldn't be the conventional take on how one would interpret it. One would normally look to those who have the most robust understanding of the act and are most readily implementing it to understand what the act means. But I can see their argument, which is essentially with serious violence, threats to violence, we interpreted that much more broadly than CSIS would. And CSIS typically interprets that to mean terrorism and violent extremism. They were using a different understanding of the same words, which is a little bit different than we thought we would get, which was that, they were taking an entirely different interpretation. Right. Or using an entirely different interpretation of what a threat to the security of Canada is. That's not actually what they were doing. They were just interpreting it much more broadly than we typically do in the context of a CSIS investigation.
Right, so if you sort of stack the testimony of the government officials brick by brick this week, it was essentially there was this constellation of factors, right? The various border blockades, the economic threat, the growing threats of violence against political leaders, the inability to clear the blockades in the downtown. And I think the clerk said today that essentially the question of whether any other act other than the Emergencies Act could deal with this, she made the point that individual agencies using individual powers could deal with individual pieces of what was happening, but nobody could handle the totality of it. And Stephanie Carvin, that seems to be, when you look at all of that, the big picture and the inability of any smaller player to deal with the total picture is what seems to be their justification for this.
Yeah, and I think this is going to also be part of the debate going forward, right? Because, Leah and I have been on the show quite a bit now, and it's fun. But we've said, like at Coutts, Alberta, it was handled by the authorities there. The Windsor Bridge was handled by the Ontario Provincial Police there in conjunction with the Windsor Police. Ottawa, a bit of a disaster. But, so I think that's really going to be the point. Like, was this something that the individual pieces could handle, or was this something that needed to be dealt with as kind of a nationwide emergency on a temporary basis that did require the kind of not just even the powers of the Emergencies Act, but we've also seen some hints that the message that the Emergencies Act was sending was also useful. So I don't know how that's going to figure into the equation, but we have seen kind of hints of that in the testimony. So
Leah West, now that we've got a clear picture of what the government's argument is, do you think this makes the use of the act appropriate under the law? I mean, there's the letter of the law, I guess, the political argument and what Judge Rouleau is going to say. And I know you've been pretty skeptical to this point. Does anything you've heard here change your view?
Well, I think we have to go back to the original purpose of including the CSIS Act definition in the definition of public order emergency. And it was explicitly to make sure that a public order emergency was only declared in very narrow circumstances. So while there may be, equities in favor of taking an expansive approach, that's explicitly what wasn't supposed to be done when the act was envisioned. I think that there is room for Justice Rouleau to say that the interpretation perhaps was justified in the circumstances, but I think that it does fly in the face of what that limitation in the act was originally intended to do.
Mm-hmm. Well, I know, Stephanie Carvin, in the opening weeks of this, you said the Emergencies Act contemplates everybody doing their job and things functioning up to this point. And we heard even testimony this week that Brenda Lucki, the RCMP commissioner, in that those two critical cabinet meetings on the 13th of February, the day before the act was invoked, she didn't speak up. She didn't brief the ministers that the police had a plan ready to go that didn't need the Emergencies Act. So given that omission, I mean, how does that play into the decision-making here by the government and maybe by the judge?
I'm going to start off by being blunt. I don't know how Brenda Lucki still has her job. I mean, her interpretation, I guess, of police independence, which has been sketchy in some circumstances, such as Nova Scotia, the Nova Scotia shootings, but then not providing any kind of operational information with regards to a situation the government is now treating as a national emergency is mind-boggling. It was just it's a stunning choice. And we did see Jody Thomas come out and I'll just go ahead and use the term throw her under a bus in her testimony, saying basically we were not told. So is that also going to factor into Justice Rouleau's thinking that, as the Emergencies Act is being contemplated, and of course the Emergencies Act requiring that, that you've kind of tried everything up until now. If the government wasn't aware that there had been a plan in place, does that kind of make it more acceptable that they were under the impression that this tool was necessary? I think I could definitely see that argument being made, but whether or not, then if you knew there was a plan in place, why didn't you immediately revoke it? That might be something that the justice also considers. Right,
because there's what we know now in hindsight, and there's what people knew in the moment, which wasn't always clear in the real-time drama of all of this. But Leah West, just a final point. The politicians start testifying next week, culminating, we believe, with the Prime Minister. What are you going to be looking for from the actual decision makers when they start testifying next week to fill in some blanks on this?
Well, again, I'll go back to the original purpose of the act and the drafters at the time. And they said, we are not going to have a perfect understanding of what might happen when we're trying to contemplate whether or not to invoke the act, right? They're working with their best guess. And I really want to understand the thought process of the elected officials when they were invoking the act. Because it's now time to establish that the ones who the people who actually chose to invoke it had those reasonable grounds, that they reasonably believed that this definition, this more expansive definition, was met, and why they felt the need to invoke the act at that time. We haven't really heard a good enunciation of why February 14th was the time that the federal government was going to step in. What was the trigger? What was the tipping point that said, now we've got it? Because things were, changing favorably in the days just around that decision.
Okay. Professor Carvin, Professor West, we'll do it again next week. Thanks so much.
Cheers.